Sorry again. I asked that you be provided with a copy of Mr. Macano's points of significant concern, really, so that you can look at it and tell us, first of all, if any of your comments were incorporated into his correspondence. Maybe that's the first question.
Yes.
Can you perhaps state which concerns you had are consistent with his?
We had talked about the capacity issues. Again, I believe he put in the hypos and the specific kind of questions in there, but we had talked about that issue of whether or not we'd have to purchase 50 megawatts no matter what, or we'd be able to purchase less or more. Those issues we had discussed. To the second point, which is the operation and maintenance fees, it's kind of similar, tied into the capacity issues, because it's also, again, what would the CNMI need to purchase on an ongoing basis or be required to take. So yes, again, those issues were discussed prior to Mr. Makanu's preparation of this document. The non-force majeure breach, if I recall correctly, he had raised that issue for the first time here. And we had looked at incorporating that into the agreement. The rate reduction, we had discussed the overall idea of a rate reduction, what numbers we wanted to see for, or what everybody wanted to see for a rate reduction. This is kind of, if I'm reading the comment correctly, it's more of a practical, how do we incorporate that, what would be the terms of. And I do not remember if this was raised for the first time here, if it was raised prior, or we had discussed it after, but we had discussed it at some point. The substation issue was a comment that he had based on CUC concerns, and he had raised it in discussions prior to the drafting of this agreement. I didn't have, that wasn't a comment that originated from me. The maintenance issue was raised and discussed prior to, and this is also just a little bit more of a drafting, how do we fit it in kind of question. The EPA issues were discussed prior to the drafting of this document.
Thank you. Is there anything else?
Sorry, I forgot page 3. Sufficient funds. Sufficient funds were discussed at some point, but again, I do not recall if they were discussed prior to or after the drafting of this agreement. They were discussed. The escrow account, kind of a similar issue. I don't remember if it was prior to or after this document, but there were issues raised by more than one person, and they had been discussed.
Thank you. Is that pretty much it?
Yes, I believe.
You stated whether it was discussed before or earlier or after, but can you kind of inform or expound on that? I mean, some of these issues were very relevant issues. The issue of what happens in the event of an oil spill or the non-force majeure breach, and the escrow account and some of the other points of significant concern do have or are significant concerns. In your involvement, you know that these issues were raised. Do you know if these issues were, we know they were discussed, they were raised and discussed, do you know if they were addressed prior to the signing?
I'll go through point by point again just so we can stay on the task. The capacity issue, we had made changes and discussed. There were interpretations of that capacity issue, and we had discussed it, and if I recall correctly, we had decided that the capacity would be determined by a dispatch instruction to be provided by CUC, and that was incorporated into the agreement.
Chair, just a point
Rep,
of clarification.
state your point.
Ms. Patel, you said that with regards to the capacity issue, that was incorporated into the finished product or the PPA that was signed?
The issues raised were discussed prior to and incorporated in various ways into the agreement.
Chair, if I may, can I?
Please continue.
Ms. Patel, let me read you what the signed PPA entails with regards to section 5.3 of this PPA. Operation. A. The plant shall be operated as a baseload generating unit for the contracted capacity, except during periods of downtime and force outages, as more specifically described in the specification and operating memorandum, subject to this agreement, and safe operating practices pursuant to the operating parameters and good operating procedures. Sdllc understands that the plant will not be the sole source of power in the CNMI, and that CUC may obtain power from other sources beyond the contracted capacity. Nothing in this article shall require CUC to purchase any power produced by the plant beyond the contracted capacity. Ms. Patel, I'm thinking that the contracted capacity is 50 megawatts. Would you agree?
The answer to your question is I'm not sure. Contracted capacity is also a defined term within the agreement that's separate and related to that provision. So if I could, if I saw the agreement, I'd be able to better answer that question. Does that make sense? It's a specifically defined term in the definition section. Yes, I believe so.
I can read it out. Contracted capacity in the definition of the in the agreement means about 50 megawatts of total net generating capacity on a continuous and reliable basis, measured at the delivery point with the actual contracted capacity to be based on the anticipated dispatch instructions provided in the specification. Do you wish to proceed?
Yes, Mr. Chairman.
Please do so.
And so I take it that the contracted capacity is for a 50 megawatts. Would you agree, Ms. Patel? Based on the definition that was just read by the chair.
Yes.
Thank you, Ms. Patel. And so, knowing this, the last we spoke with CUC, or the acting executive director, he had given us a demand capacity, a present demand capacity, which is somewhere between 30 megawatts and 35 megawatts. So, if we're looking at this provision, 5.3 of this PPA, CUC, or the ratepayers, I would say, would have to be paying for an additional 15 megawatts that we really don't need. On top of that, I'm thinking that all these talks about alternative renewable energy would be useless because this provision locks us in to 50 megawatts whether we need it or we don't. In other words, these companies that plan on coming in and tie their equipment, whether it be solar or any other renewable alternative energy, would tie their systems in, and we won't be able to use it because we would be paying this additional 15 megawatts that we can't use or need because of this provision. Am I correct so far, Ms. Patel? Do you think the logic?
I don't know if that's completely accurate, as it involves some of the engineering knowledge that would be within Mr. Fletcher's expertise, and so I can't, I don't know how to answer that question because I do not know if that's actually correct.
Thank you, Ms. Patel. I recall that when you started making your statements, you had indicated that you had spoken with engineers as well as CUC. Who were these engineers and where did they come from?
Before the contract was the first draft of the contract, there were some engineers that would be working with Sdllc that came to meet with CUC. And so that's where they came from, and that's who they are.
You don't happen to have names of these individuals that you had discussions with CUC?
Off the top of my head, I don't remember the names. They were prospective, and the meetings that I had personally attended were more on a broad level.
So prior to the signing of this PPA, did you read the final version of the agreement?
Yes.
Were you present during the signing of the PPA?
Yes.
And who was present there during the signing?
Obviously the governor was there, Edward Buckingham was there, Michael Wilt, Gilbert Burnbrick, and I believe Alan Fletcher was also present at the day of signing, and I don't remember if there was someone else.
Thank you, Ms. Patel. And prior to that signing, on your own personal or professional opinion, before they inscribed their signatures on the document, did you think that this agreement was good for the Commonwealth? I know that the legal questions were answered. You said that it met legal sufficiency and so forth, but did you think this was good for the CNMI?
Rep. De la Cruz, I'm gonna move on to the other members. So,
Representative, the answer to that question is a little bit difficult again, because there were various inputs from various expertise that contributed to whether or not every provision or the agreement as a whole were good, and some of those areas are outside of my personal field of knowledge. So for me to answer the ambiguous question of whether or not the agreement as a whole is good, I don't think I could do that.
So I guess then it's safe to assume that you weren't sure whether it was good or it wasn't good.
Well, it had been input had been provided from different areas, so different people had been trusted to do kind of different areas of input, and I incorporated that input. So,
and based on those incorporations, you felt that this PPA was still not the PPA that maybe we should enter into. Would that be something close?
and I can't answer that question. It wasn't my task to determine whether the overall agreement was good for the Commonwealth or not good for the Commonwealth. That, of course, falls within.
That's good. Thank you. Thank you, Ms. Patel.
Thank you, Representative De La Cruz. Before I entertain other members, I wasn't actually finished. I can appreciate, your role was not to determine whether, you liked it or not, or whether you agreed with the contract. But you did provide your technical your comments regarding the legal issues which you referenced several times: force majeure, other parts of capacity, rate reduction, the EPA issues. My question is more specific. You raised the issues. Now I know you mentioned that it was discussed and there were adjustments of the contract provisions. Doesn't really answer it. If there were relevant concerns that you raised, were those concerns addressed? Meaning, to me it doesn't matter that they changed the language of the provision of the contract. What matters is, was the contract amended to ensure that the concerns that you raised were addressed? And maybe a simple yes or no answer would do. And if you wish, you can go point by point, regarding non-force majeure, regarding the other concerns that you raised one by one. Was this addressed, and maybe how was it addressed in the contract? Or just a simple yes or no would do.
Some of my concerns were addressed in the contract. I wouldn't say every single point or issue that I raised was addressed in the contract.
Thank you. That's a fair statement. But because you did raise these concerns, I'm pretty sure you probably remember the ones that they didn't address because it wasn't. Most of us would not forget the ones we tried to raise but wasn't. Can you enlighten us as to which areas did you provide recommendations and it was not addressed? The more significant ones.
I want to provide an accurate response. So your previous question was what concerns were addressed in the contract, and the current question is which of those concerns were not addressed in the contract. Or those concerns, at least the majority, if not all of them, that weren't addressed in the contract were discussed amongst various individuals involved with this agreement, and ultimately the decision maker decided they either didn't need to be in there, or based on that, some of them were technical questions, which again somebody else would know better than I.
I understand. Thank you. But the ones that you did know about, as I stated, or let me restate it again, the more significant points that were not addressed, something that in your mind may be a serious flaw with this document that could negatively impact the Commonwealth, or the ratepayers, or CUC, something so obvious that, ma'am, we go back to the whole point of this is to try to identify, again, whether this contract was in the best interest of CUC, the ratepayers, the people, the government, and we were not party to that. And to reach a decision whether in fact this is a good contract or not, we need to rely on those individuals who were part of the negotiations, were part of the review of the contract, and were whose role it was to identify and address parts of the contract that may not be in our best interest, and where That's why we're asking these questions, and I've been getting really very general answers, and I'm trying to understand what, at least, maybe not everything, but the more significant points of concerns that you had that were not addressed. Can you please share with us your answer?
Just to clarify, you mean not addressed in the final version of the contract itself?
Yes, ma'am.
There were some issues with engines, size, speed, etc. that I had suggested we put into the PPA agreement itself. Those were ultimately decided to be put into either the specifications, the dispatch instructions, or the operations manual. That's one that I remember.
Maybe I can be more specific, ma'am. I have an email from you to Miss Archer. And you have provided a review of the escrow and pledge agreement, which you attached as exhibits to the power purchase agreements. Now, the escrow and the pledge agreements are two specific and separate agreements from the power purchase agreement. We've been talking about the power purchase agreement all morning, or so far. With regards to the security, or I'm sorry, the escrow and the pledge agreement, what was your finding of those agreements, your review of those agreements, and what was your finding?
So if I recall the email to Miss Archer correctly, she had sent over a PDF of the agreements, all of them that are referenced therein, and when I had looked through them, I had noticed that the signature pages on some of those exhibits, which agreements probably, I don't remember exactly, but they had been wrong. They didn't have the correct people that I was told would be signing the agreement, and so I think that's the email that you're referring to. And there were also, yeah, I believe it was the signature pages that were incorrect. They had also made some changes, some ink and pen changes that needed to be initialed by someone on our side.
That's correct. But did you review the escrow and the pledge agreements on as an assistant attorney general? Did you review it for? Did you just review it first?
I believe between Tiberius Makanu, myself, and Gilbert Barnbrook, we reviewed the three attachment agreements, which includes the guarantee along with the escrow and the pledge and security agreement. Which one each of us read through, I'm trying to remember, but I don't remember exactly which one, which assistant attorney general read through which of those three agreements, but we each read through one. I think that Mr. Malkanu reviewed the pledge and security agreement, and
I'm only interested in you right now. We will ask them separately.
Sure.
What did you review?
I believe I had reviewed the escrow agreement.
Did you what was your finding based on your review?
When I'd reviewed the escrow agreement, I had very minimal time to go through and review it. I'd only had about maybe half an hour or 45 minutes to look at it. So that wasn't, the PPA for obvious reasons was the main focus of our review within that 2-week period of time. And I hadn't seen the escrow until just right before. There were issues within them. I don't recall which ones were specific. There were an overall concern amongst all three of us actually that there was a lot being pledged, but there were other concerns that kind of were balanced against it, I guess.
Thank you. And before I dismiss you, are there any other members that have questions? Representative Sdllc.
Thank you, Chairman. Ms. Patel, I know it's getting late, but just quick question. Have you looked over the March 27th agreement?
Can you repeat the question? I missed a word in there.
Have you had the opportunity to look over the Power Plan Development and Management Agreement dated March 27, 2012?
I've seen it. That agreement was negotiated, signed, etc. prior to my being involved with this project or with the Attorney General's office at all.
Okay, and I understand that, and that's why I asked you whether you've ever seen it, because I know you came on board sometime in April. The agreement was executed in the last part of March. So the question again is, have you had the opportunity to look over the March 27 agreement?
I've seen it. I haven't reviewed it.
Okay. Has any section of this agreement been discussed while reviewing the August 3rd agreement?
The only provision that I have been party to being discussed was the 20% reduction in rate to the...
And you know, the reason I want to ask this, and I don't know whether you're the person to ask of this, but under section 3.4, it mentions it's entitled involuntary termination due to changes in law compact. And I think about the second sentence there, it says, the CNMI agrees that the CNMI and its agencies, departments, commissions, boards, or other regulatory authorities will not enact or pass any laws, rules, regulations, or ordinances subsequent to the execution of this agreement, which will materially impair the rights of the developer under this agreement. It continues, likewise, CNMI and its agencies, departments, commissions, boards, and other regulatory authorities will not enact any tax law, rule, regulation, ordinance, or imposition that will put the facility or the enterprise at any portion thereof in a competitive disadvantage. Is in this condition of this agreement infringe on the constitutional authority of the legislature in your opinion?
Those provisions, there's a constitutional provision, both in CNMI and in federal constitution, that prohibits the legislature from impairing contracts in particular, and so that provision was meant to address that impairment. So legislature wouldn't ordinarily, or I mean, it's complex, but in certain circumstances have the ability to impair a contract that is already signed.
And that is why I mentioned the second part, because on the first part where it says impair the rights of the developer, I understand that you don't pass laws to impair or negatively impact an existing contract. But where it says to place at a competitive disadvantage is that's the first time I've seen that. And we're generally talking about general laws here, tax laws, rules, regulations. I mean, this is a blanket prohibition, wouldn't you say? The first part, I agree with the first part where it says impair. But the second part of it where it generally, it's pretty much a generous blanket statement.
I don't know. I know that.
Well, let me excuse you from answering that, because, and I guess when this particular issue or this particular requirement becomes an issue, this particular section of this agreement mentions final determination by any government authority or a court of competent jurisdiction. However, it says that before you get to that point, that the two parties get together and try to amend this agreement. But it says in the last sentence here, it says, in the event such amendment is not practical, performance of this agreement shall be automatically suspended, effective upon the date that performance of this agreement becomes unlawful. Can you explain what that particular line means?
I didn't draft that provision. It would probably require some kind of legal analysis to adequately and accurately answer that question. And it would also require me looking at the agreement and seeing how it matches with other parts of. And I don't want to be difficult or vague. It's just hard to answer a question when I don't have any agreement in front of me.
Okay, the reason I ask this is this. The PPA that was signed on August 3rd practically would privatize the power generating business for the CNMI. If, for example, at any point after an operation of the power plant, this particular issue comes to light or becomes an issue, would this sentence, in the event such amendment is not practical in any regards that affects the operation of the power plant, performance of this agreement shall be automatically suspended, would that include not providing power plant, power to island customers?
It's hard to. There may be other provisions that affect the interpretation of what that sentence says. So for me to give you a proper legal answer as to what the effect of that sentence in a long contract means with respect to that entire contract, it wouldn't be a proper and adequate answer, because I need to look at every single other place where that comes up and where the different changes in other provisions of the contract may override that part, or provide an exception to that part, or something else. So without flipping through all of the pages, I don't think I can answer.
Yeah, because the March 27th agreement, I'm assuming, maybe you can correct me, lays the foundation for the in-detail agreements signed off on August 3rd. Is that a fair statement?
That's a fair statement.
So the company, Saipan Development LLC, can always fall back on the March 27th agreement.
I hadn't performed a review of the March 27th agreement, and so if I understand your question correctly, it is that if for some reason, and for argument's sake, the August 3rd agreement is invalid, void, whatever, then they would come back and say that the March 27th agreement is enforceable and would try to enforce some rights under that. Is that what you're asking me?
Yeah. The first part to this section, the impairment part, I understand, and I think everybody here understands that. But have you ever seen the second part to any contract that you've dealt with? I mean, I ask that based on, the separation of powers between the executive and the legislature. And here you have the executive speaking for or committing the CNMI legislature to something that is not a party to.
To answer your question, I have not seen it in any contract that I've written before or reviewed before.
Thank you, Ms. Patel. Ayub.
Thank you. We have 15 minutes before our next line of witnesses come in.